Good evening, everyone. My name is Peter Crane, and I'm chair of the Ad Hoc By-law Committee here in Rutland. We have a guest. That's fantastic. So I have someone to talk to. That's really marvelous. I expect people to be joining through Zoom. Norm said he'll join. We'll see who else does.
All right.
But this will be an informal walkthrough of chapters 5, 6, and 7 of the bylaws. Chapter 5 are the committees that we haven't already discussed. Committees, commissions, the chapter's called multi-member bodies, so it doesn't matter what kind it is, we just have a bylaw for them. Chapter 6 is public and private ways. We have several bylaws there, and then Chapter 7 are the bylaws that haven't been modified, that haven't been brought up to, that have not been completely reviewed, put through all the review process. So they haven't been reviewed by the Bylaw Committee in completion. They haven't been put through any other review process. Those will be put on a future town meeting warrant, but there are a couple that we had to change. I'll discuss that when we get there. Let me share this. No, share that screen. That should be much easier. So, this chapter is in nice alphabetical order. So, being multi-member bodies, the first thing is Agricultural Commission. We currently have an Agricultural Commission bylaw. We've updated it some. Most of the changes have to do with incorporating all the powers that are defined in Chapter 40, Section 8L, which is the enabling statute to have an agricultural commission at all. A couple years ago, that section of general laws was updated to give expanded powers to the Agricultural Commission. We've incorporated many of those powers into this bylaw. So if we just run through it, as usual, we have our purpose, authority sections, and then we go into membership. This actually has a significant set of changes to it because we have membership requirements for appointed committees, and AgCom is an appointed committee. We have an entire bylaw that talks about all the things that appointed committees, how they're formed, what the membership parties look like, how appointments are dealt with. So anything about that wasn't specific to AgCom has been removed. Now the thing that is specific to AgCom is all about alternate members. Our original bylaw had alternate members. Our new version has alternate members, and just like the current one, alternate members are appointed to a term of 1 year by the select board. So there's no functional change there. We just got rid of a bunch of words that duplicated text other places.
May I make a comment?
Please.
That's the best thing that ever happened. I'm on the Ag Commission, and being an alternate, I fill in so many times because a farmer can't make it or whatever for a meeting, fill in.
Which is an important thing. I mean, again, this is, it is an important note. I glossed over this, but I'll hit 3B. A minimum of 3 members, so 3 of the 5 members, so a quorum of the primary members shall be actively engaged in agriculture. So, generally speaking, actively farming. It now doesn't mean it has to be that doesn't mean that has to be the primary income, but that's helpful. As more and more farms go away, we'll see if this has to change. But for now, this is a provision that was in the current law and it will continue through this edition. Moving down, many of the duties are directly from the old bylaw, and if not from the old bylaw, then from 8L. So, many of these have had some amount of minor rewording, but I don't believe that it changes anything substantial. Hi, which party are you looking for?
Not this one, right?
Bylaws? Come, join the bylaw party. Bring gifts. So, Commission encourages the pursuit of agriculture and agricultural-based economic opportunities. This actually ties very well, I think, with the accessory agricultural use bylaw, the zoning bylaw that was passed last year. Commission acts as mediators, advocates, educators, and/or negotiators on agricultural issues. So when there is a conflict, or whether it's a full-blown conflict, or even just somebody needs to a different set of eyes for anything agricultural, AgCom is the right body to go to. Commission shall coordinate agricultural-based activities with other governmental bodies or unofficial local groups or organizations that promote agriculture. Basically, AgCom is the focal point for everything agriculture in the town. And if anybody else wants to interact with the town on an agricultural matter, AgCom should be involved, unless it's for, something to do with a farmer. But if the state says, we don't like what you're doing, and the farmer says, but this is what, if there's a disagreement there, AgCom can help one side of and act as a mediator. This one's a little soft and squishy. Commission shall work towards the preservation of agricultural lands. I think everyone would prefer that we maintained more land. Everyone. Okay, that's an overstatement. That many people in town would prefer that we maintain more of our agricultural lands rather than have them be developed. And so commission is responsible towards that work of maintaining them as to their abilities. Hi there, bylaws.
Wrong one.
Everybody's going to the crumbling foundations.
Yes.
So the commission shall pursue initiatives to create and maintain a sustainable agricultural community. Again, a little soft and squishy, but it sounds fundamentally like the right group to be doing this. And finally, a nice catch-all: commission shall perform other activities that are consistent with the commission's purpose. Anything agricultural, and the commission believes it should get involved, it can get involved. I believe, looking at this, that all the duties are in the current bylaw. I'd have to go back and make certain, but I believe that to be true. It's powers that we extended some. And there are some changes to each of these powers, even the ones that were in the current bylaw. So the commission may apply for, receive, expend, and act on behalf of the town in connection with federal and state grants or programs or private grants related to local agriculture in accordance with the town's grant acceptance policy. So the town does have a grant acceptance policy now, and sometimes the select board needs to be involved and sometimes they don't. And it's up to AgCom to follow that policy when they're getting ready to receive or expend gifts or grants. The commission may receive gifts, bequests, or devices of money or personal property of any nature and interest in real property in accordance with Chapter 40, Section 8L. Yep, that's a newie. That's a new one. And this wording comes straight out of 8L. So this is an extension of their current powers, limited only by what Mass General Law says. The commission may buy, hold, manage, license, or lease land to other parties for agricultural purposes. That doesn't sound like that's the most recent version.
No.
Let me look, because this is the one I did, but I can look at... I would swear there were more words. Nope, that is the current version of this bylaw.
Oh, wow.
And it's because, again, Mass General Law gives the commission this explicit power. Actually, 8L gives it slightly broader powers. AgCom by 8L may do all this for agricultural or recreational purposes. But the Bylaw Committee felt that that created potential conflict in the town because we already have a Conservation Commission who has authority to buy, hold, manage, license, or lease land for recreational purposes.
Okay. I had something in the back of my mind I've been planning for a long time. And because it doesn't have the rec in that thing,
Well,
I gotta think
You just go through a different body to do recreation, that's all. And finally, oh, that's why, because we added D. Any acquisition of property by the commission shall be subject to select board approval when future town spending may be required for such property. So, let's just say that they get, that AgCom wishes to acquire property with a house on it. That house needs to be maintained, which means somebody has to spend money on maintaining the house, or has to spend money to demolish the house, whatever. Anything that will require future town spending must be approved by the select board. Questions or comments?
Unless the commission can sell that particular part of a parcel.
And if that's the plan, I see no reason why the select board wouldn't approve, but it's,
Okay.
the acquisition still requires approval.
Oh, yeah.
Okay,
I'm happy.
that's, oh, let me get that right. Close just a second. I have too many windows. I can't see everything I need to see all at once. So now we go to the Bylaw Committee. Very similar to what is already in existence for a Bylaw Committee bylaw. There were a few things. Again, just like in AgCom, we removed all the pieces that belong in Chapter 4, the membership section, that deal with, that are already mentioned elsewhere, because we don't like repeating ourselves. So, just like today, it's a 5-member board appointed to staggered 3-year terms. That means that it's only, with 5 members, everybody's up every 3 years, so 2 years in a row you'll get 2 members up for reappointment. In the 3rd year in the cycle, it's only 1 member. You know, there could be vacancies for any reason, but that's how it's done. And we explicitly say town clerk and town administrator shall be ex officio non-voting members. Those are 2 officers who the Bylaw Committee strongly believes should be involved in bylaws as early as possible. Again, most of this is the same as it is today. If a town official asks the Bylaw Committee shall assist the town official in drafting changes to the general bylaws. The committee may assist. So somebody comes in and says, I have an idea for a bylaw. The Bylaw Committee gets to decide whether or not they're going to help that resident. Shall I? Yep, okay. One of the things that we talk about further down is that, in fact, you can see it. No, you can't see it. It's just off the screen that the Bylaw Committee is responsible for periodically reviewing the entire body of town bylaws. So part of that, even with nothing else, that will periodically cause changes to bylaw, or will cause the committee to propose changes to bylaws. So the committee proposes to the select board the changes that believe should be made, and then the select board decides whether or not it should be put on a town meeting warrant. D is actually a new one. Oh wait, no it's not. No it's not. This is, so let me just pick a particular example. When the stormwater bylaw was put through, the DPW commissioner, director, superintendent did the work with external parties to generate the bylaw and brought it to the town just in time for town meeting. What this says is that the Bylaw Committee is responsible for reviewing all general bylaw changes proposed by town officials. So anybody who makes up their own, that's okay, but it still has to be reviewed by the Bylaw Committee. It also says the committee shall review all proposed changes to general bylaws requested by citizen petition. So this is up to the select board to receive the petition and to forward them to the Bylaw Committee for review, so that the bylaw committee can make its recommendation on the town meeting floor. And just like magic, the committee shall report to town meeting its recommendations. Committee, and G was the new one. So when the town votes to approve an amendment to a bylaw, that then has to go to the Attorney General's office for review. And after they review, they may say approved with no comments, approved with comments, rejected, we striking this section for this reason. So what we put in was that the committee reviews all the Attorney General decisions about general bylaws. There were, in fact, are specific cases where the Attorney General has said, you amended this section and that's fine, but you should know that this other section of this bylaw actually isn't legal because in such and such and such a case law, you should review with town council. That's what the bylaw committee should really be doing also, to make sure that we are up to date with case law, that the town's bylaws are up to date. Committee shall conduct a complete review of the town's general bylaws at least once every 6 years to ensure consistency with changes to applicable law. This is that case where the Ad Hoc By-law Committee is the first body to do this since 1941.
Wow.
It's been a very long time, and that's one of the reasons that there's so much to be amended at this and future town meetings. And so the Ad Hoc By-law Committee believes strongly that there should be a regular review, and the review is 6 years because that's 2 complete cycles, appointment cycles for the committee. It also has to do with how frequently you're allowed to attempt a bylaw amendment. There are a lot of things going on there, and there's a 5-year thing also. What was the 5-year thing? I don't remember off the top of my head, but 6 is just a little more than 5. It works out with the appointment cycle, so it sort of ensures that there's a continuing review as membership in the bylaw committee changes. Committee shall assist the town clerk in preparing the publication of general bylaws. So as we make the book, as the town clerk is responsible for making the book, but the committee's responsible for the content until it's approved. So the creation of the book and how we get it printed, how we get it on the website, that is all the bylaw committee's job, to assist the town clerk when the town clerk wants that assistance. And the committee shall assist with formatting, structure, presentation, and publication of the town's zoning bylaw when requested by the planning board. The planning board are the keepers of zoning bylaw. The town clerk and the bylaw committee are responsible for the general bylaws, and together they make up all the bylaws of the town. If the planning board wants our help saying, yours looks nice, can you help us make ours look nice? I think it makes sense. Bylaws.
What is it?
This is bylaws.
No, we're looking for the,
Foundation, big room at the other side.
Thank you.
You're welcome. So this section 7 is what we are doing here tonight, and as we've done in 2 previous sections. As long as there's time, which is what makes it practicable, Bylaw Committee holds 1 or more public information and input meetings to discuss general bylaw or proposed general bylaw changes. That lets the public have an understanding about what's going on. Just like this is it's not being televised live, but it's being recorded, and it will be broadcast on TV. And hopefully that process continues as the Bylaw Committee moves forward. There was one other change here. It used to say that notices in a newspaper in general circulation in the town, which is the way most of these are written. We changed it because there is a posting policy in the town. This is not a hearing, this is just a meeting. So we don't have to meet any law requirements for hearings. We only need to be a meeting, and so we only need to publicize or to post notice in a way that's in accordance with the town's posting policies. Section 8, same as it was before. If something happens and we don't get the full review, or we don't get the meeting, or the moderator doesn't ask the bylaw committee for its input, or whatever, if the town adopts a bylaw amendment, it's permanent, even if every step in the process that's laid out is skipped. Because at the end of the day, the town, through town meeting, decides what's in the bylaws, period. Questions on bylaw committee? So we've done A for agricultural commission, B for bylaw committee, and now it's C for council on aging. This is substantially similar to what was there before. Yes, there are probably 100 little wording changes, but it's fundamentally the same. We very substantially reworked section 1, which is the purpose. And we took that really based on what the general laws says a council on aging should do. We thought it sounded better than what was there before. We did not change, we had some serious discussion about, but did not change the size. So the size is still, the size of the council is set every year by the select board. Now, I don't know what happens if the select board says you're going from 7 members to 5 members, and there are currently 6 members. I don't know what happens. That's not something I'm going to be able to solve here. And then there are also 2 alter members, just as there are today. That's all there is to this bylaw. The duties are really covered by Mass General laws. That's what they do. And council, well, I wouldn't say the council reviewed, I'd say that the chair of the, I think she is, yeah, she's chair of the Council on Aging, and she runs the senior center, has reviewed this bylaw and had no suggestions for improvement. Questions on Council on Aging? Skip over D and go to the Earthworks Board. This is a relatively new bylaw, so it turns out that the only thing that's changed of any substance is we removed the membership pieces that were duplicated elsewhere, just like every other bylaw. It's the same construction, same terms. We could actually have made some of this a little smaller if we had tried, but oh well, I'm not going to worry about it too much. Now, because this board is composed of members from other boards, mostly, we have a single at-large member, but everyone else comes from a board. That's why D is there. So if I'm the member from the Conservation Commission for Earthworks, so if I were not reappointed or resigned from Conservation Commission, I would automatically resign from Earthworks. So that's all that D says. Questions or comments? All right, that's Chapter 5. It's complete. All 4 bylaws, all done. They're fairly easy. I don't think there's anything serious, anything controversial in them, so we're just going to move forward to public and private ways. So, the first question is, what the heck is a way? And that's a good question, and the answer is, it's a road, it's a sidewalk, it's a path, it's anything where people can travel that's owned by the town. And a private way is something that's like that, but not owned by the town.
Like an easement.
There could be an easement for travel, yes. Easements get a little funny in law, but fundamentally, if it's a public easement, then the public has an absolute right to travel. This is bylaws. If you're looking, the other one is other side of the library. So, this bylaw, what is now called public ways, used to be called highways, but we thought that the word highway gave the impression of high-speed travel with the way the word is used today. So it's, what we're discussing here are any public road or sidewalk or whatever. Enacted under Article 89 of the Massachusetts Constitution, which is the Home Rule Amendment that lets the town write bylaws that are not otherwise injurious or offensive to Mass General Law. So I'm going to skip over the definition of debris. It's basically anything that doesn't belong in the road. Section 4 is just a rewording of what's in the current bylaw, which is there's somebody, the DPW superintendent, who's responsible for removing snow and ice from the public way. So if somebody puts anything in the way that prevents snow removal or emergency services, DPW can take, somebody puts a car in the wrong place, blocks a road, that car's getting towed, and that's too bad. This bylaw gives that official that explicit power. And as it says, the owner of such vehicle shall be liable for the costs of such removal and any storage device charges, any storage charges resulting therefrom. So after it's towed and it goes to, I'm just going to pick a space, Bill's garage, and Bill's garage charges a fee for the towing and charges a fee for storage. The owner of the car, not the driver of the car, the owner of the car is responsible for paying that before they get their car back. Another one that's in the current law, you're not allowed to place debris, as we said, anything that doesn't belong there, in the roadway without written permission of effectively the DPW superintendent / commissioner / director. So if you're going to store, if you're doing a project that abuts a public road and you need to use a piece of the road for a time for temporary storage for materials, something. Number one, don't store them in the road if you can avoid it. But if you can't avoid it, get written permission from the DPW to do that.
See, I always thought that was also snow. If somebody plows their driveway and puts it in the road, that's an obstruction.
That is, in fact, it is, because as you can see in the definition of debris, snow and ice.
Okay.
So snow and ice is included in that as well.
Yeah.
So don't push your snow into the road. Push it across the road to somebody else's property, or hopefully your own, but come on.
Yeah. Sometimes I try to help out the town, and I can't do sometimes as good a job as they can, so I do leave some snow there, but I feel that I'm just trying to help. But I do see other people, though, make an attempt to get rid of their snow into the road and let the town push it off the side, and that to me is not.
It's not kosher, they're not supposed to do it.
Right. That's what this is about.
Around me, people tend to push them across the road
Yeah.
and onto the other side of the road, which is generally, for the places I've seen it, not inhabited.
Yeah.
But yes, you're right that is not right. I remember when I was growing up in a city and we had to shovel we had to make big piles on our property, and if they were over our head, that's how high we had to throw them, because you couldn't throw it in the street.
Yeah. Just a side note of this, have you asked DPW director, has he issued, or the police, have they ever issued any?
I have not asked.
It would be interesting to know, because if it's something that needs to be taken care of. Once this thing has gone through, I take it this is already in effect, or this is just being updated?
This is being updated, so these provisions for sections 4 and 5 already exist.
Already exists, yeah. It would be interesting to find.
And in fact, there are entries in the fine table. That's something else we can look at
Yeah,
if there's time this evening.
okay, all right, well, good.
Okay, moving on. After public ways, scenic roads. Just a second, let me get to all my notes about scenic roads that are not completely up to date, but I'll figure it out what changed. So there are some substantial, other than just wording changes and expression changes, there are some pretty significant changes between the current scenic roads bylaw and this one. This one tries to be much more clear on how the processes are supposed to work. That's what we tried to do. Those are the biggest changes, because with everything that we've seen recently, the Ad Hoc By-law Committee did not like all the issues that we saw creeping up around how they're proposed, how they're changed. There was actually a bit of discussion around town, because it's not obvious from the current bylaw, but it is possible to remove scenic road designation. But that's only mentioned once in the entire bylaw, and it's sort of it's sort of said as an aside, something nobody would ever do. And I don't know that that's true. The committee doesn't know that that's true. And we'll talk about the implications of that as we get to it. So this is all enabled by General Laws, Chapter 40, Section 15C, which lets the town write a bylaw that discusses scenic roads, designating something as a scenic road, removing the designation, and what is allowed to happen without a permit, what changes are allowed to be made without a permit. And we've actually made some changes there also. We'll talk about that as we go through. So, I'm not going to go through the definition. I don't know that it's valuable to our time tonight. There I am. So, repairing, maintaining, reconstruction, paving. Oh, everybody knows what a road is. People knows what tearing down a stone wall is, and people know what a tree is. It's interesting to note that there are if a tree is smaller than 4 inches in diameter at 1 foot, so any tree that's measured to determine whether or not it's subject to this bylaw, you have to measure it at the right spot, or more accurately, calculate it, because the diameter is a calculation from the circumference. And if it's 4 inches or more, then it's jurisdictional. If it's less than that, then the town has no jurisdiction over it. Do what you want with it. Okay. So, how is a designation made or removed? A town body considers the recommendation and talks about it amongst themselves. Now the Mass General Law specifically talks about Historical Commission, Planning Board, and Conservation Commission. We do not have those restrictions here because we think that anybody should be allowed to recommend it. Any town official should have the power to recommend it if they believe it. There are little pieces that are a little different and a little easier for Concom planning and historical, but let's not sweat that right now. So, what is very, very, very important, and something that has not been reliably done until now, is that The way it's worked is it suddenly shows up at town meeting and nobody knows why. And nobody knows how. And nobody knows who. A requirement of the bylaw is that whoever is considering recommending a road be designated or removing a designated, they must hold a public information session meeting where the public is allowed to provide comments. How many times have we heard, I mean, what is it, Irish?
Yeah.
People have, there have been requested designations without the people who live on the road being informed that it was being suggested. That's a big problem. It's not transparent government. So this bylaw requires a public information session. And that meeting must be held before any recommendation is made. So there's I'll just pick Concom, since I'm on it. Concom thinks it wants to make a scenic road designation or remove scenic, but we'll just say make a scenic road designation. We can talk about it all we want, but we're not allowed to vote and to actually take an action until we've had a public meeting, and we'll talk about all the notice and who gets to be invited and all of that. But if there's no public meeting, the board is, committee, whatever, is not allowed to vote to recommend, period. So, that meeting has to be 7 days before the body votes to recommend. And notice, published in the form and location approved by a select board. Now, again, this is not a public hearing. Frankly, most boards in town can't afford the costs of sending a public hearing notice to everybody who lives upon a segment of road they want to make scenic. It's too darn expensive, and the newspaper posting is also expensive, and if there is no budget, then it can't be posted, and we don't want that to be a holdup. But we do require that it is published, again, according to the posting policy. So the hopes is by the, sorry about that. The hopes are that the publication policy will be broad enough and well publicized enough by the nature of putting it on the town website, on the electronic board, posted in 7 places around town, put on the website, that notice will be sufficient so that people won't be surprised when it comes up. The other important thing that is, again, not historically conspicuously done is that a committee says, we're going to hold a scenic road discussion. No. The public notice for the meeting, and not just, but the agenda for the meeting, must include the name of each road or portion of road being considered. So that way, people on Ridge Road who read the agenda and get the notice will know we're talking about making Ridge Road or a portion of it scenic. So they can at least know to show up to the meeting and give comment.
Yeah.
Now, if copy of notice will be sent to planning, conservation, and historical, and again, if it's conservation won't send it to itself, that's not a meaningful thing, but because since we will have made it, we have the copy, but we have to let planning and historical know. And if it's not one of these 3, they have to notify all 3. And again, because of the costs, notice need not be sent by mail to landowners along the roads. And I'm not happy, but I don't have a solution that solves the problem, so we've got to move on. So, there was discussion in whatever board. There was a public information session. There was a public meeting. At least 7 days later, that board meets again and says, yes, we want to make this scenic, or we want to remove the designation, whatever. When the recommendation comes from the Planning Board, the Conservation Commission, or Historical Commission, again, the three boards specified with the power in Mass General laws, then the Select Board shall consider placement of an article on the next town meeting warrant. If it's not one of those three bodies, the Select Board may choose to completely ignore the request. Again, there's a requirement. This is the process that the town really has to follow to be sure that we're following MGL. Along with the recommendation from, I'm just going to go back to Concom, has to be a written description of the characteristics of the road that justify making it scenic or making it or removing the scenic road designation. Here we go. The final act, what actually makes a road scenic, is vote at town meeting. A road or portion thereof shall be given scenic designation when a simple majority so votes at town meeting. So if it's a simple majority, if it passes with 50% plus one of the vote, it's a scenic road. But to remove, we've had a lot of discussion about this in the Ad Hoc By-law Committee, excuse me. A road or portion thereof shall have scenic designation removed when a 2/3 majority so votes at town meeting. This request came from Historical, and frankly, I can't think of a really good reason other than I don't like it. I don't like that it's not symmetric, but I can get out. That's a personal thing. I can't think of a good reason, a good objective reason. So this is what we are proposing. Okay, so there are changes. Many things can be done that do not require any approval whatsoever. Normal road maintenance, for example, does not need, when the DPW throws more gravel on Brittenall Drive and more dirt and fills in the potholes, don't need approval for that. So, if you're going to take no more than 3 trees per 200 linear feet along the boundary of the right-of-way, within basically whatever's jurisdictional to the town, then the tree warden can allow that without a hearing. Sign a piece of paper, you have permission, go. But if you're going to do any painting, removing, or destruction of stone walls, or modification of stone walls that alters or conflicts with the character. So if you had a field stone wall and you're replacing it with one of those newer, flat shim, thin rocks, that's not keeping in the character. That requires a permit. Cutting and removal of trees in excess of this scope, so it's more than 3 trees per 200 linear feet. Then there has to be written permission of the planning board, and that requires a public hearing. You do need permission from the planning board to reconstruct your driveway at the interface to the scenic road. Get out of the public right-of-way, which is generally behind the stone wall, because the stone wall is usually the boundary. You could go up to that border, do anything you want there, that doesn't need it, but anything from that boundary to the street itself is all public right-of-way, and that needs permission from the planning board. Now, that, all that we talked about so far is in the bylaw today. We did add E. Changing the road surface from unpaved to paved requires approval of the planning board. Not that we think that's going to happen. Now, it is a mistake a mistaken belief people have that because a road is made scenic that it cannot be paved. That is not correct. There is nothing in scenic road designation that prevents a road from being paved. All we're doing is we're adding a little extra a process to the DPW before they do it.
Yeah.
And again, this all has to do with making sure the citizens, the people who live along the road, know what's happening.
Yeah.
And it's not that they all have to approve, because the citizens don't get to approve it. But here at least they will be notified because there'll be a hearing.
They'll have an opportunity to speak their opinion.
That's right.
One, I don't know if you have it in here, but as you're coming down on C up above, what about, you know, when we had that ice storm state of emergency, does that overrule everything?
Emergencies are covered much later that say, if you've got an emergency, deal with the emergency and do the paperwork within 30 days or whatever the time frame is.
Okay.
There is a time frame, but yes, emergencies are emergencies.
Yeah.
There's no time for hearings in an emergency.
I was gonna say,
When we're reconstructing all the electric lines across through most roads in town, come on, let's. So yes, we do have that provision in here.
Very good, thanks.
So somebody who wants to make changes requiring approval submits an application to the appropriate town authority. So again, it's going to be the tree warden, if you're doing just trees and just a small number of trees, or it's the planning board and tree warden sometimes, if you're and planning board if it's stone walls, and both planning board and tree warden if you're doing stone walls and too many trees in an area.
Yes.
So that person submits an application in writing, town authority, after determining the application is complete, forwards a copy to the other authority, so that again, we're trying to improve communication and transparency so that DPW probably doesn't care that stone walls are getting changed or that someone wants to change stone walls, but at least it keeps them informed. And also, just again for documentary purposes, the application also goes to conservation and historical, as the people who have power to make it, and whoever made the designation, fine. But again, we're going to hard put requirements for communication to improve communication in this town. Whatever it takes to make copies, whatever it costs, the applicant has to take care of them. As usual, no work that requires town approval may begin until all the approvals have been received. So if you've got trees and stone walls and you don't have approval for both, you may not start either. And then tree warden and planning board shall be notified within 5 days of the commencement of work to allow, yeah, this is the one, it's 5 days, it's not 30. So when there's an emergency, if you believe there's an issue on your property that needs to be dealt with here and now, get a police officer out to say, yes, this is danger. Cut the darn tree. Get it out of the way. And then within 5 days, send in the paperwork that describes what you did. So again, when permission is required from the planning board initiates the hearing. Even if it's a hearing for... A single hearing can take care of both tree warden and planning board. If it's just tree warden work, and it's with, that no more than 3 per 200 linear foot, the tree warden can just give permission, sign the application or whatever, and it's done. But anything that requires planning board approval requires a hearing. And that one hearing will be for both planning board and tree warden jurisdiction if necessary. So there we go. So notice of a hearing this is planning board, and we go to Mass General Law, and they define how to make notice, which is newspaper, mailing abutters, all of that. And again, the costs have to be borne by the applicant for that. And the application, copy of it goes to Select Board, Concom, Historical, Tree Warden, Department of Public Works. And all abutters within 300 feet, that's a change. It used to be only 100 feet. We're saying, after consideration, we said that this abutter list should be the same as any other planning board hearing. And because it's a planning board hearing, we'll have planning board rules rule, and it's a 300-foot list instead of a 100-foot list.
Gotcha.
So, planning board holds a hearing, considers its normal criteria. No significant changes or consequential changes here. It's just, yep, planning board needs to consider all this stuff. So, it is the power of the town authority, so it could be a power of the tree warden, and it can be a power of the planning board to require compensatory action. So if you're going to destroy 300 feet of stone wall, they might say, well, we see how long your frontage is, and we see that there isn't stone wall over here. Replicate the stone wall over here. That's possible. Or something else. I don't know what else the planning board would have for a compensatory action, but stone wall is stone wall.
That's what we've done in the past.
Right. So they have the hearing, they decide what they want to be done. Town authority, planning board, or tree warden notifies the applicant of the decision within 30 days of the close of the public hearing. And a copy of the decision is sent all around the town. I believe this is out of MGL, and if it's not, it ought to be. The planning board may adopt regulations, sure. They have not, to my knowledge, but they have the authority to adopt and promulgate regulations. Fine. This is another place where we did substantial rewording, but we don't think that the meaning of it changed. So somebody can notice that a tree was cut down or stone wall was destroyed, and the town official, depending on who they are, if it's a police officer, for example, can issue a citation. Planning board can issue a citation, tree warden can issue a citation, police officer can issue a citation, building inspector can issue a citation. Whoever notices the violation sends a copy of the citation to the tree warden or planning board, depending upon what kind of violation it is. Then tree warden and our planning board define and write down any compensatory action based on what took place and the timeline the action is expected to be performed. And if somebody doesn't perform the action in time and it's not extended by the planning board or the tree warden, then there's a fine every week until the violation is remedied. And again, is remedied to the satisfaction of the planning board or tree warden, as the case may be. At the end of the day, those are the authorities for the work that needs to be done. And that's it for scenic roads. Questions or comments?
On this, we do get to the fines
Yeah, we'll get to the fine table.
someday.
The fine table has not been reviewed by all the...
No, but I'm just saying, I've got some to bring.
Okay, great. So let's move on. So this used to be called permit for entering highway. And again, what's the definition of a highway and how does that used in the vernacular? And so we said, no. This is how you connect a driveway to a road. And all this says, and all it's ever said is, you need to get a permit before you connect a driveway. That's all it says. Now, you need a permit from the town to connect to a town road. This can't apply to a state road, 122A, because that road is owned and managed by the state. Unfortunately, it's not obvious, but not all numbered roads, not all numbered routes are state roads. Route 56 is a town road. Route 68 is a town road. 122 and 122A are both state roads.
Yeah, and then what if they are jointly town and state? In the center of town from Palmagussit to Maple Ave is joint
Then you'd need it from both.
from both.
So, if it is joint and you only get it from the town, the state will come after you. If you only get it from the state, the town will come after you, right?
Yeah.
Yeah, that's what we need more than anything, is even more governmental bodies in the middle of things.
I don't want the state to give up though.
Fair enough. And, okay, that's it for connecting driveways to roads. This used to be called bylaw to establish official names for streets. Nope, just street names. That's all this is. Let me look at this. Okay, so for this one, there are not a large number of consequential changes. The biggest one, so the way it is now and the way it will continue to be is that the authority for naming of roads rests with the planning board. But we added, after consultation with public safety officials, town clerk, and board of assessors.
That's not the way it is right now.
Correct.
I believe it's just a town clerk.
No, it's planning board today.
Today is,
Yes.
so somebody's not coming in with a subdivision, they still,
They still have to go to the planning board. So this is new streets. We're not talking about renaming. We'll talk about that down in section 4. But,
new streets, not a private way.
yep. Well, it doesn't matter if it's public or private. This applies the same. That every single street name must be approved by the planning board.
Alright.
So if it's not part of if it is part of a subdivision, it naturally goes before the planning board. If someone were cutting in a new road, I don't know who, I don't know why,
Yeah,
in order to get a name for that road, you have to go to the planning board.
alright.
So once the planning board needs to consult with public safety officials, town clerk, board of assessors. You know, you've got to talk to fire
Yeah.
and dispatch and
Oh, yeah.
police so that they can all give their blessing to make sure that the name is sufficiently unique. And the assessors have sort of that same role.
And that I have seen over the years that I've been in planning, and names have changed because of that.
Yep. And this one, I believe, is new. I don't remember, I'd have to go back. Town clerk shall maintain the official list of all public and private street names.
Yes, we're in that situation right now.
Well, at no point does this talk about a certified list. We're not saying certified, we're only saying that the keeper of this list of names is the town clerk.
Not certified, huh?
I was wrong. I thought for sure we'd run longer than Finance Committee tonight. It's Wachusett. I just saw the Wachusett folks leave.
Oh, wow.
Oh, sorry, distraction.
No,
Look, something shiny.
But to me, before you can have an official list, you should have something that everybody's done the paperwork on. That's why I'm saying certified, to make sure that it, in the past, it hasn't been taken off the Commonwealth.
There are all kinds of discussions about that going on and how we're going to deal with things and make sure we have the right list moving forward. I can't do that. All we can do is say the list is the responsibility of the town clerk.
Okay. How we get there is another subject.
Yep, how we get from where we are today to where we have a list with which we are certain,
Yeah.
or of which we are certain. So it is also possible to change the name of a street, something that may happen soon. So we'll ignore the exceptions in general laws. The approved name for a public or private street shall only be changed by majority vote of the town. So there are multiple ways this can happen, but basically, if the select board says, yes, we approve, we recommend this change, then it only needs a simple majority of the town meeting. If the select board does not recommend it, let's say it was done by citizen petition, then it's by 2/3 vote. Can a street name be changed? And once that happens, town clerk shall cause to be recorded in the registry of deed a copy of any such vote, changing the official name of a street, and the change shall become effective when so recorded. So, there are a number of pieces of paper in the registry of deeds. And one of those is registered land drawings, which for subdivisions have street names on them. And so we need something in the registry when a street name changes from what was recorded in the original documentation. So that's what B is for.
Good.
Questions or comments? Moving on. We changed from bylaw to establish a uniform system of numbering houses and other structures to structure numbers. There are a few truly consequential changes. Oh, and I need to fix that also. I see a formatting screw up I need to fix, but let's move beyond that. That's not important right now. This big change number 1, in the current bylaw, the planning board assigns structure numbers, which has not been happening. I don't know that it has ever happened, but it's what was in the bylaw. We are changing that to be the town clerk has the authority to set structure numbers after consultation with the Board of Assessors and assent to the fire chief. And you assign different numbers to different things. An apartment building will have one number for each dwelling unit, even though it's a single structure. A business that has multiple buildings will likely have different numbers for each structure, depending upon what it does. But you're not going to have a structure number for a barn or a garage. So there's some latitude here based on what the town clerk believes needs to be done for which structures get numbers and which ones don't need them. And we were not explicit because we don't think there's value in being explicit, because no matter what rules we came up with, there will be exceptions.
Garage today, apartment tomorrow.
And you might need one then, that's right.
Yeah.
Change in use. Because it becomes a dwelling. So this 4B is long and obnoxious, that shows, that really defines what the beginning of a street is. And even then it's a little ambiguous, but it's fundamentally the center of town is the smallest numbers, and everything, and numbers radiate outwards from the center of town. All the words that are here, with perhaps some formatting changes or some clarification, are the same as what's in there now. And how do you define left and right? What direction are you facing? Your back is at the center of town. Or the intersection of the road you're intersecting with, blah, 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 blah. This is another difference. The current bylaw has one number per 100 feet. We made it one number per 50 feet. It's because of estate lots and the minimum frontage of certain.
Oh, the estate lots.
That's where things get complicated. Again, the best idea we could come up with was reduce the number to 50 feet and move on.
Blame
Now,
the,
what's
blame
that?
the planning board.
Hmm?
Blame the planning board.
I'll do that, sure.
Okay.
Now, I do want to go back up here, and you notice that a structure number is a series of digits, sometimes with an alphanumeric suffix. So, 6A Glenwood Road. I'm making up an address, obviously. That's legal. It's actually a bigger deal in apartments, but you get the idea. Town clerk notifies the owner of a structure and other appropriate government agencies, fire, assessors, dispatch, etc., when a number is assigned. Now, there are some real differences in displaying numbers. The part that hasn't changed is the structure's owner shall cause the assigned number to be displayed in accordance with this article. So what does the rest of this say? Okay. If you're close enough to the road and the view is not obscured, then you have to put the numbers on your home. On the structure. If they can't be viewed from the road for any reason, then you need something pretty much at your driveway entrance with the numbers on it. It could be on the mailbox. It can be on a sign. It can be all displayed numerals, because it could be written out. 30-6 Glenwood Road. I forget, I've seen them in some places.
Yeah.
That is a numeral. That's not a number. So the numeral should be made of weatherproof material, shall be at least 6 inches in height. And, now this is the change, now it says only shall be of a color contrasting to the area surrounding said numerals. The current one says it's got to be black or contrasting. But if you've got a really dark house, black is not going to show up. So we said, if it's a light color, you put black on it. Now, let it be obvious. It's got to be visible from the road. Or on the sign it's on. It has to be contrasting enough so it sticks out.
6 inches. When did that come into effect?
It's in the current bylaw.
So that was all the way back to the 60s?
This bylaw showed up in 57.
57.
So I can't say that it, actually, I have no information that this bylaw has been amended since 57. So I haven't found any evidence of that, which means that it since 57 has been that way.
Wow.
So D is where it says if you can't see them, put them at the beginning of the driveway. Put them somewhere so they are visible from the roadway. And finally, the structure owner is responsible for maintaining the visibility and legibility of the numerals, period. Nothing unusual there. Questions about structure numbers?
We'll have to tape measure them all.
So believe it or not, that's almost all we're doing at town meeting.
Wow.
So that's chapters 5 and 6. We've already covered 1 and 2 in February and 3 and 4 in March, and now we're doing 5 and 6. And now we're going to look at bylaws to be updated, which is, alas, a small misnomer. So I'm not going to pull them up here. I'm going to pull them up. I've got to find the 3. Hold on. So let me actually take a moment and remind everyone that if you go to the Town of Rutland website and go to Boards and Commissions Ad Hoc By-law Committee, over on the left side, Proposed Bylaw Updates. This is everything that we're doing and the status of everything. So I'm not going to go through this whole thing. I've talked about it too much at length before. But I'm looking at this because I need to look down here with for the future. So Chapter 7 is bylaws that have not yet been reviewed and updated and modified. But there are a couple modifications to door-to-door solicitation, peddling, stormwater management, and signs. Let me go back and show. Let me go to the general provisions. This is very important, and it's a little, it's not alphabetical order. Loser. So we have 2 definitions that are very important. One is, what is a day? It's a calendar day. That's easy. But what words do we use when we want to say excluding Sundays and holidays? And we actually added Saturdays to this list as well. And we called any day that is not a Saturday or a Sunday or a holiday a working day. And we had to make itty-bitty changes to the door-to-door solicitation, signs, and stormwater to make sure that we did not have a conflict with these definitions. So I'm actually going to pull up a different document. So let me, instead of looking at our nice PDF, let's pull up door-to-door. And let me bring you up here. So this is the current bylaw as close as I can get it to its current format. That's the way it's going to be in the book of bylaws. And over here on this side, those are the amendments. So as I scroll down here, you are not going to see very many changes. It's blank because there are no changes until oh, okay, itty bitty change because there was a typo. And so I fixed the typo. We fixed the typo. Scrolling down here, so notice of hearing for revocation or suspension. It only said, so what we wanted to do is to remove all of those days excluding Saturdays, Sundays, and holidays and replace it with working days. In this case, the bylaw only said 5 days. And it is the Ad Hoc By-law Committee's firm belief that that is not 5 calendar days, because when things, if the 5 days before the hearing is a Sunday, there's no way they can get notice. So we made it 5 working days to be consistent with our definitions in section 1. And this is exactly virtually all you're going to see other than typos. And I think, there's another one. There's a typo because this said appear, but it's really appeal. That's why the R was deleted. Such appeal must be filed within 5 working days after receipt. So it's the same thing. You've got to make it practicable and consistent. And that's the changes to the door-to-door solicitation and peddling. Let me now go to the next scary bylaw, which is it sure looks scary. This is a big, complicated, highly technical bylaw, stormwater management. And fortunately, we only did a couple things. I just have to find my cursor again. So we'll just take a scroll through it so you can see all the changes. None so far. There we go. This bylaw stormwater used business day, which is okay English, but again, we don't have a definition of what a business day is anywhere, not even in this bylaw. So that makes this inconsistent. So we're changing the word business to working, just to make it consistent with our definition. And obviously these are the 2 places where it was done. And let's see if there's anything else. Nope, that's it for stormwater. And finally, signs. Signs is a big, 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 massive bylaw. We're gonna have a lot of not so fun trying to tear it down and rebuild it into something better. But just scrolling, looking for the change bar. What the heck? I don't see what changed. We deleted the 9, insert. Oh, it was a misspelling. So it's a typographical error. It used to be COMMERICAL. So it was chimerical rather than commercial. Scrolling, 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 scrolling. Yeah, I'm calling that a typographical error because it was 32 without a hyphen. And again, we inserted working. 3 working days after the event. Events on a Friday, you've got till Wednesday to pull them down. Event is on a Saturday. You have until Wednesday to pull them down.
And that relates to election signs too.
Yep, sure does. Same deal as we saw in stormwater. We replaced the word business with working days. I'm sure the vernacular business days isn't really that ambiguous, but here we go. That's it. That's all the changes to signs. So all we have left to look at is, and I don't plan to go into this in depth, the schedule of fines. The table is laid out differently, the contents fundamentally are not different. There are a couple of things that we've added, I'm not gonna take a lot, but what we tried to do is to make references with the new formatting so that we say chapter and article numbers so you can find what the bylaw is, what the topic, well, what the name is, and therefore the topic, and also in some cases, different sections. So you have one violation for section 4 public ways, a different one for section 5, 2 violations in scenic roads, etc. This is the nature of the offense. So this is, by the way, putting snow and ice in the road, and this is putting other stuff in the road that interferes with the removal of snow, ice, or emergency services.
I think that's where I was gonna talk to you, is that one.
All right, I just want to look at one thing before I go too far, because I do want to see. See, the problem is sometimes it's all how you present it. So if I go back to the original Word document, right, scenic roads had one of the violations in it, but not the other. So we added the second scenic roads violation. What did you want to talk about, Dick?
No, my thing was, up above, making a change along a scenic road.
Mm-hmm.
I think along should be within, because you're along the scenic, but you're not saying where. But I know in general, people should know where it is.
It's within the right of way.
But sometimes there's no stone walls, there's nothing there, so.
Yeah.
I'm just saying within the scenic road. And,
Well, it's not just the road though. It's within the right of way, which is much wider than the road. So that's why we said along the road, because people aren't going to dig up the road proper. They're going to do something along the road within the public right of way.
it's large.
But send me email, we can talk about it.
Yeah, okay.
Again, I'm not going to hit every one of these things.
Yeah.
If it's not blue, it's in. So the blue ones are the new ones that we just added. If it's not blue, it was already in the fine table.
Yeah, no, that's some reason or other I had right after scenic road, bounds without a permit. But maybe what you're saying is just gotta sink in, that's all. That's all I had on that page.
Okay. Stormwater is new. It's the contents are taken directly from the stormwater bylaw. And when, well, this is complicated, but if there are any fines in a bylaw, they were all repealed when this table was first published. So, I put this in so that we have consistency between what's in the stormwater bylaw and what's in the fine table. All the animal control stuff is just as it was. We added violations to the door-to-door solicitation and canvassing or peddling or whatever it is. Different violations. Waiting for feedback, we'll see, from police. Looking for feedback from the building inspector for any changes to the signs or zoning bylaw, or planning board for that matter also. Oh yeah, I was supposed to change zoning enforcement officer to building inspector to make that more clear. I'll try to remember to do that. So that's violation of bylaws. Now, this all used to be one giant table and it was a mess.
Yeah.
So this has all been separated into, I think, 4 tables, and so the first one is all town general, no, not general, just town bylaws. Next one is town regulations. The first 2 are crossed out because there are currently no regulations for outdoor wood boiler permits. Town doesn't have any regulation, and the Mass General Law that enables us to require a permit requires there to be a regulation in order to issue a fine. Because there is no regulation, they may not issue a fine. I'm not pulling it out of the table until closer to town meeting, because the Board of Health can enact regulations fairly quickly if they decide to do so. And if they do, we'll put it back in and that's fine. So that's true for the permit, and that's true for public nuisance complaints. We do have private well regulations, and we do have Title V regulations. So those can be fined as the Board of Health or the health agent likes. We do have specific Mass General Law sections that we fine against. Handicap parking, open air permit, open air fire, and abandoned motor vehicles. Those are all standard. They've been in the fine table for as long as the fine tables existed, to my knowledge. And then there's state regulations. Now, these are state regulations that the Board of Health is allowed to directly issue violations against. And finally, this is a really long section from a previous building inspector with sections of International Building Code and Massachusetts amendments to that building code. And they're very generic, and excuse me, those building codes are actually highly specific. So all of this is just the sections and the violations that the building inspector wanted to fine against. I have no idea how many of these have ever been fined against, but the question I've heard a couple times is, hold on, go back down. What is an illegal swimming pool? It's a swimming pool built without a permit. That's the only illegal swimming pool I can think of.
Not because it doesn't have a fence. Just, I didn't know that swimming pools never had. Well, we did have one when I was a little kid, but
Yeah, at some point, the law came in where you need a fence to protect the
Yeah.
youngsters from crawling in and drowning. But it's not, I haven't actually been through 3109, the IBC, and it was originally called illegal swimming pool, but I would imagine the first thing is a pool without a permit shouldn't exist. And by having the permit, the building inspector knows to go look at it and inspect it.
okay.
So I would imagine that also, that not having a fence could easily be a violation of this section as well. But I don't know, I'm no expert here.
Did not know swimming pool needed an inspection.
Yep. You need a permit.
Permit on everything. In
Pretty
order
much.
to suck an air, you gotta get a permit.
That's right, to improve your lungs. And that is all the changes. I invite everyone, if you haven't seen them, to review the other 2 programs about bylaw amendments. They're on YouTube, they're on our video on demand library. Please feel free to talk to the town clerk about getting a copy. The book is, I think, 155 pages, so it's a long book. And It's one of the things I love to call narcolepsy inducing. That is to say, you're going to fall asleep reading it because this is not scintillating stuff. So please review it all. Be aware of what's going on so that when it all comes up at town meeting, and it's going to come up in May's town meeting unless something particular happens, plan on it. That's one of the reasons town meeting starts at 4 in the afternoon on May 7th, folks. Be ready.
Yeah, be ready.
Showing up at 6 or 7 o'clock, you'll miss a chunk of it. Dick, any other questions or comments?
Yes, in case anybody that does watch this, and they're interested, and maybe want to get more involved with you people, check the website out. You're here Tuesday, most generally at 1 o'clock.
That's right. And we know Tuesday at 1 o'clock is a tough time to meet, but
Yeah.
fortunately, my nights are already too busy. So yes, please, feel free. So we've talked to the town clerk, Anita Carlson, and she says that it's okay to send her questions or comments directly, and she's part of the Ad Hoc By-law Committee, so if you send anything about bylaws to her, she'll inform the committee, we'll know. And we'll discuss it. Every bylaw and the fine table, they're all in legal review. Doesn't mean they're locked, it just means that it's a little more process to change it. But when legal review is done, hopefully before May 5th, then we will be in, everything will be locked down, there's not much we can do. So I thank everyone for your attention, for your support, for those who have helped us, thank you all very much, we appreciate it. And unless there is a reason not to, unless there's something else, and nothing else, so I am going to end this meeting. Thank you all very, very much. We look forward to seeing you at town meeting.